Good day, good morning, good afternoon, good evening, whenever you are, wherever you are, and however you are. My name is Charlie Rose, and this is the Trial Advocate. We're going to continue engaging in our series of discussions about the four pillars of professional responsibility, the things that you need to have in order to establish your house of professional identity, to properly avoid losing your license as a practicing lawyer, and perhaps to assist young law students in studying for a professional responsibility exam or in getting ready to take the multi-state professional rules of exam as well. My goal in these presentations is to provide lawyers with thought processes that help them and assist them in navigating these issues in a way that ensures the self-regulation of the system, the adequate representation of clients, and the development of lawyers as agents for change and representation in a democratic society. That's what we're about. Let's get started. Today I'm going to be talking about lawyers' duties. I'm going to be talking about the duty that a lawyer has to themselves, to their clients, to other folks who work with them, to the tribunal, and where conflicts of interest can occur and where decision points arise when we're dealing with lawyers' duties. And I'm doing that so that we've got a clear sense of what we're supposed to do and why we're supposed to do it. And it allows us to go back and review the law, review the code of conduct, and put it in context so that when we actually find ourselves in these positions, we can apply an understanding of them to the work in question and do so ethically, competently, and maybe even, if the gods are kind, compassionately. Let's get started. When I think about lawyers' duties, the first one is to the client, and my duties to the client include confidentiality, attorney-client privilege, and attorney-client work product. The principle of client confidentiality is an ethical rule. It is a rule that ensures that what the client tells me remains inviolate with me. I don't share it with anyone else unless it's necessary in order to effectuate the representation, with some limitations. If the client is going to ask me to commit a crime, if the client wants to use my services to commit a crime, or if the client informs me that they're going to commit a future crime, I have the opportunity to potentially pierce confidentiality. The attorney-client privilege, on the other hand, is an evidentiary rule. It is a rule that bars the presentation of evidence that prevents an attorney from testifying against a client. And in most situations, I can have a violation of confidentiality, but the attorney-client privilege has not been waived because the privilege is held by the party asserting it, usually the client. And so I can disclose in a violation of Rule 1.6 and deal with the ethical consequences, but still not be required or forced to testify against my client. Folks often conflate principle of client confidentiality and attorney-client privilege. It's important that you understand where they are connected and where they are separate. And then, of course, we have the work product doctrine. The work product doctrine you find a lot in the rules of discovery. We're concerned about not having to give opposing counsel the stuff that we've prepared in anticipation of litigation that's laying out the means by which we will accomplish the objectives of the client. And we have a right to keep that stuff private and not provide it. And there are labeling requirements, and then there's what do you do when it's inadvertently disclosed? How do you get it back? How can you ensure the opposing side doesn't rely upon it? And all of those issues are there, and they're important, but work product has more of a discovery issue to it than anything else. And it's also connected to client confidentiality and to some degree attorney-client privilege. But it is its own entity in and of itself. Remember that the rule of confidentiality comes from the model rules of professional conduct, and attorney-client privilege comes from the evidentiary code of your jurisdiction. In the federal rules of evidence, you can find it. It's also in the common law. Let's take a look at where client confidentiality applies. Judicial proceedings, whenever I'm called to give evidence, and whenever I disclose information in furtherance of representation. In each of these instances, confidentiality applies, and there has to be an intervening force or exception that allows me to violate confidentiality. And where that does not exist, I cannot pierce the veil of confidentiality and disclose information. And it's in the relationships between the lawyer and the client and in the specificity of Rule 1.6 that we see where those exceptions arise. But you should accept as a singular concept and professional responsibility this idea of attorney-client confidentiality and the need, particularly in an adversarial system, for it to exist. It actually forms some of the underpinnings for why we have conflicts of interest rules. And so this idea of confidentiality, of being the confidant, to some degree even the confessor of the client, is very important in order to ensure the proper workings of a legal system. Now, under the rule of confidentiality, we do have some implicit authority to make disclosures. I would put to you that when you're drawing the line as to what should be disclosed, you look at what is normally disclosed in the type of representation that you're involved in, what is the scope of your representation, and whether or not you've informed the client ahead of time. These are the types of things that I'm going to talk about with opposing side. It's usually best to disclose to the client what you intend to talk about before you do so. It's particularly important to do so if you're not sure whether or not disclosure is warranted in the scope of the litigation. And you got to remember always the decisions that the client makes and that you as the lawyer don't make. There are some things that they can assert assert confidentiality on, even if you think it's non-important. They can, for other reasons, not want you to disclose it. There are some times when they'll not want you to disclose something that would be helpful to them because they've decided not to for some other reason that's valid. So you've got to have that conversation. You've got to continue to inform the client in your duties to keep the client informed. The duty to keep the client informed of a matter and to proceed with competence and diligence actually connects to this idea of confidentiality. It's much easier to maintain the confidences of a client when you have appropriate modalities of communicating with the client. When you are keeping the client informed, where the objectives of the litigation have been identified by the client and the means of achieving those objectives has been explained by the lawyer to the client. This communication is key. It occurs during the formation of the attorney-client relationship, and then it continues through the course of representation, and we need, as practicing lawyers, to understand this concept and to make certain that we're handling it in the right fashion. The rule of confidentiality itself comes from Rule 1.6a, and if I go back and look at the rule, this is what it tells me. A lawyer shall not reveal information relating to the representation of a client unless the client gives informed consent, the disclosure is impliedly authorized in order to carry out the representation, or the disclosure is permitted by paragraph B. So I have three primary instances where I can disclose information. When the client says it's okay affirmatively, when it's the type of thing I have to disclose to do the job they've hired me to do, or when one of the exceptions of Rule 1.6b applies. Most of the issues regarding waiver of confidentiality or violation of confidentiality, the piercing of that protection and disclosure of information, usually revolve around Rule 1.6b. And Rule 1.6b is a rule that is different from jurisdiction to jurisdiction. The slide that I've got up here is the rule from the Model Rules of Professional Conduct as found in the Delaware Rules of Professional Conduct. Different jurisdictions have a different take on this. So for example, you'll see, a lawyer may reveal information relating to the representation of a client to the extent the lawyer reasonably believes necessary in the following circumstances. Now you'll notice it says may reveal in the model rules. In the state of Florida, for instance, it says shall reveal. You must reveal. You don't have the choice of not revealing. The first instance is when it's to prevent reasonably certain death or substantial bodily harm. The second one is to prevent the client from committing a crime or fraud that is reasonably certain to result in a substantial injury to the financial interests of property of another, and in furtherance of which the client has used or is using the lawyer's services. So, we're worried about death or grievous bodily harm, and we're worried about fraudulent use of our services to steal money. And in both of these instances, I have the potential to reveal, even though confidentiality would normally require me to keep it quiet. And I go through a balancing test. I look at the factors and I decide. You'll notice a couple things about this. Both of these are positing future outcomes. They're looking at a potential death or a potential injury or a potential loss of money. It's something that hasn't happened yet. If the client comes to you and this instance has already occurred, you may be able to continue representation. Although if they've used you in furtherance of their fraud, you may have a requirement to withdraw. But particularly when a client comes to you and says, hey man, just want to let you know, last night I took my wife out for a nice dinner. We went to the beach. I beat her in the head with a baseball bat, and then I buried her underneath the sea turtle eggs. She's out there now. I'm hoping that the crabs will get her and she'll just decompose. And I wanted you to know that. That crime is complete. It's happened. It's not ongoing. I can't go to law enforcement. I can't tell the people at the Environmental Protection Agency that the sea turtles are now nesting on the corpse of someone's wife. I have to keep that private because it's not an ongoing crime. Rule 1.6b would not apply. I point that out to show you the temporal nature of Rule 1.6b1 and 1.6b2. If I look at 3, to prevent, mitigate, or rectify substantial injury to the financial interest or property of another that is reasonably certain to result or has resulted from the client's commission of a crime or fraud in furtherance of which the client has used the lawyer's services, or to secure legal advice about my compliance with ethical rules. So when I go to another lawyer, I can tell them what they've told me. But we know that when I go to another lawyer and they tell me, and I tell them something, they can never disclose without my permission. And that's designed to allow me to get legal advice without fear of reprisal and to continue to protect the confidentiality of the client, who's probably created the legal conundrum for the lawyer to begin with. And you'll notice that ongoing harm or past financial harm that can be rectified also allows for potential disclosure. I mean, you could read 1.6b, 2 and 3 and think, at least to a certain extent, that we're more concerned about financial damage than we are about human life. And there are scholars who have written in those areas. It's a balancing test. It's a balancing act. We have competing interests here, as we always do in the law. Now, 5 and 6 tell me that I can disclose if I need to establish a claim of defense against the client. The client accuses me of malpractice, tries to get money from me, or let's say the client accuses me of ineffective assistance of counsel, and says that that is a reason that I should be allowed, that they should get a new trial. In those instances where they are attacking my professional reputation or trying to take my property from me, I can disclose to the extent necessary. But what I should do when I do that is not disclose to the point that I violate client confidences unnecessarily. I should disclose just enough to represent myself while also protecting the other confidences that are underneath the surface. It's a delicate balancing act. When you find yourselves in this position, you should, of course, consult with counsel. And then, of course, to comply with other law or a court order. God help you if that ever happens. It just means that you've got an issue. There is the crime fraud exception. This Rule 1.6b is often referred to as the crime fraud exception. And when I break it down into its component parts, what I see is that the client intends to commit an illegal act, and you have evidence of that. The burden to show that the attorney-client privilege or confidentiality is not applicable falls on the shoulders of the party trying to invoke the crime-fraud exception, and it applies only to ongoing or future crimes and frauds. It does not apply to crimes or frauds that had occurred in the past. If the client waives, I can disclose. When disclosure is needed to represent the client, I can disclose. Past physical harm to people that's complete, I'm going to have a hard time arguing that it's ongoing. So in most instances, although factually there may be some occasions, in most instances, past harm is going to be more difficult to pierce the protection of confidentiality. Threaten physical harm to people, if I have a viable belief that is actually going to occur, then I have the ability to disclose under Rule 1.6 in the model rules. I have a requirement to disclose under the Florida rules. And then I have to look at how valid I think that belief is. I'll give you an example. Let's say we have a client, we're a marital lawyer, we do divorces, and our client is demonstrably upset. He's screaming, he's crying, he's enraged, and we calm him down. And while he's upset, he's saying, I'm going to kill her, I'm going to kill her, I'm going to kill her. I'm going to go to her house, I'm going to shoot her in the head, I'm going to strangle those kids. She's not going to take those babies away from me. I would rather they were dead. He goes on and on and on and on and on about it. But you calm him down. You get him back to equilibrium, and you say, hey, look, you can't do that. You explain. You feel like you've got him on the right path again. And then as he's leaving, he says to you, hey, do you do criminal work as well? Could I have your business card? Is that a threat and physical harm to people such that I have a duty to disclose? If it is, and I have a duty to disclose, how great is that duty? Do I have a requirement to go to the police and tell them everything? Do I call the lawyer of the opposing side and let them know that his client's in danger but not tell him why? I mean, what do I do? Where do I go? Well, one of the first places I would go would be to get an advisory opinion from the bar, because if you get an advisory opinion and you act in concert with that advisory opinion, you should be okay. In addition to getting the advisory opinion, I would probably, talk to another lawyer and get advice on what's the appropriate thing to do. That's just an example of how that can happen. And then, of course, we've got the threat of continued client fraud or other economic crime. Let's shift gears a little bit now and talk about client perjury. You have an ethical duty regarding perjury. Your first duty is to ask who committed the perjury. Was it the client or was it a witness? And if it was the client, am I in a civil proceeding or criminal proceeding? Is the perjury prospective or is it completed? Is it a criminal or a civil case? If the lawyer reasonably believes the evidence is false, she may refuse to offer it under Rule 3.3c. She may refuse to offer it if it's from the client in a civil case or from any witness in either a criminal or civil case other than the defendant who has the constitutional right to testify. This standard of reasonable belief is the standard rather than actual knowledge that the client's testimony will be false. And that reasonable belief must be based on independent investigation of the evidence or distinct statements made by the client. It can, of course, be based upon both as well. So in this instance, I can prevent testimony if I believe that perjury is going to occur, unless it's the defendant in a criminal setting. And I can't prevent the defendant from testifying because they have a constitutional right to take the stand and explain what they did or did not do. So when I think about client perjury, I go back and look at Rule 1.16, declining or terminating representation. I look at Rule 3.3, candor towards the tribunal, and I look at Rule 3.4, fairness to opposing party and counsel. and I put those rules together as I think about how I'm going to move forward from a perjury perspective, right? You cannot counsel or assist a client in fraudulent or criminal conduct, and you must not remain willfully ignorant of facts. You can't put blinders on. And if I go and look at Nix v. Whiteside, the Supreme Court case, it tells me that my first step in a criminal instance is to try to convince the client not to commit the perjury. And Nix v. Whiteside says that the right to representation does not include the right to commit perjury. That right to assistance of counsel doesn't give you a right to lie. Now, civil cases don't raise this constitutional issue, and the lawyer can refuse to put the client on the stand. But if you discover that you've offered false evidence to the court, ABA Model Rule 3.3 requires you take reasonable remedial measures. And most state codes are even more, shall we say, stringent. Perjury, particularly perjury that is suborned by a lawyer or put forward and vouched for by a lawyer, is anathema to a justice system, and we just don't have, it doesn't have any place in our thought process. So, in conclusion, we've talked about lawyers' duties as it relates to the client. We've talked about confidentiality. We've talked about where confidentiality can be pierced and why it might be pierced. We've also looked at the issues revolving around attorney work privilege, attorney work product, and attorney-client privilege from an evidentiary perspective. Guys, the duty of lawyers falls into several different categories. And in this block of instruction, I've talked about duties to clients. In others, I'll talk about how we deal with other individuals who are part of the justice system, the way in which we talk to judges, and the way in which we deal with opposing counsel. Till next time, this is the Trial Advocate, and I'm Charlie Rose.